today. As so many of her colleagues on the opposition benches are cheering this decision, we see an opposite view here. Today is a bad day for the British people. Today is a good day for the people smugglers. It is a good day for Labour. As ever, from the Shadow Home Secretary, there is no regard for the will of the British people. I know she sees the will of the British people as an inconvenience and an irritation, because her statement demonstrates that she simply has no empathy for the impact of illegal migration on local communities. She fails and refuses to recognise that those crossing by small boat, Mr. Speaker, are doing so illegally. And as ever from Labour, there is no alternative plan. And moreover, they don't care that they have no alternative plan. Because, Mr. Speaker, the truth is that our current system is rigged against the British people. That is why we are changing the law. The Labour Party is perfectly content with this rigged system. They'd like to keep it in place. That's why they're opposing our illegal migration bill. That's why they would scrap our partnership with Rwanda. And rather than propose any meaningful reforms to the asylum system, Labour would keep the system as it is to enable more people to come to the country illegally so they can be settled into local communities more quickly. That is simply open borders masquerading as humanitarianism, and she should be honest with the British people. I also wonder if the Right Honourable Lady actually read the judgment, given her gleeful disposition. So let me repeat some of it to her. While the Court of Appeal did find by majority, with a dissenting view from the Lord Chief Justice, that there were deficiencies in the Rwandan asylum system, specifically relating to the risk of refoulement, all other grounds on which the appeal was brought were unanimously dismissed. That means that the policy does not breach our obligations under the UN Refugee Convention. It does not breach our domestic laws, as the Right Honourable Lady and the opposition have consistently maintained it would. As I've said, we will appeal the disappointing aspects of the judgment, or seek permission to appeal them. But I think the British people will see quite clearly, Mr. Speaker, that while we are trying to stop the boats, Labour have simply obstructed progress time and time again and offered no solutions. The Prime Minister and I have promised to do whatever it takes to stop the boats. Labour have apparently pledged to do whatever it takes to stop us stopping the boats.
Can I just say, gently to the Home Secretary, this is about the statement of the judge about migration. This isn't about the Labour Party. This is about what the government's doing. I don't want to interfere, I don't want to intervene, but we do need to stick to what the statement's meant to be about. Home Secretary.
Thank you, Mr. Speaker. So, in conclusion, in any event, while Labour continue to celebrate today's judgment and continue to celebrate every obstacle in our way, we will not be deterred, we will not give up, we will do whatever it takes for the British people to stop the boats.
Thank you, Mr. Speaker. Whilst respecting the authority of the Court of Appeal, I share the Home Secretary's disappointment of their judgment. I welcome the fact she's going to take it to the Supreme Court. Does she think that the case for the Supreme Court will be strengthened if she firstly brings forward the safe and legal routes now written into the illegal migration bill, so there are clear options for genuine asylum seekers not having to use irregular or illegal routes? And secondly, can she write into the Rwanda agreement a default position that if the Rwanda government does try to move on those people to a third country, there's a default position, a right of appeal that could be heard in the United Kingdom? Does she not think that those measures might strengthen her case for the Supreme Court judgment? Because certainly from the front bench opposite, we've heard not a scintilla of any practical solution to this problem.
Well, my Right Honourable son makes a good point, and as he will know, and I'm very grateful for his constructive input, the illegal migration bill that's currently making its way through Parliament does make reference and contain provisions relating to safe and legal routes, and we are in discussions about how and when those routes will be rolled out. They're an important element to our overall plan to stop the boats. It's vital that we do support those genuine claimants in need of support. And that's why I'm very proud of our track record, supporting and welcoming 500,000 people through humanitarian routes to the United Kingdom in only a few years recently.
Go to SNP spokesperson Patrick Grady.
Again, I thank the Home Secretary for advance sight of her statement. The Home Secretary says that she's disappointed by the High Court's decision, but in fact, is she not being a bit coy? Is she not actually delighted? Is this not exactly what the government wanted all along? A fight with the judiciary, a fight with the House of Lords, triangulating the official opposition. Doesn't this play straight into their dog whistle agenda? And the human rights of people fleeing war, oppression and famine are simply an afterthought. The economic assessment finally dragged out of the government last week shows the eye-watering potential cost of the Rwanda scheme to the taxpayer and the cost of the wider implication of the illegal migration bill. So on top of the £120 million that she has already paid to Rwanda, why is she now determined to put even more cost on the public purse by further appealing this ruling to the Supreme Court? Or has that also been part of the plan all along? She says her dream is for planes full of refugees taking off for Rwanda. Is it not actually that she's dreaming of the opportunity to take the UK out of the European Convention on Human Rights? Because Scotland wants no part of the Tories' hostile immigration environment. Despite the ludicrous claims of her immigration minister earlier in the week, Glasgow and communities across Scotland are proud to welcome refugees. We need immigration to help develop our economy and enrich our society and culture, and we want to offer refuge to those who need it most. So while they refuse to devolve immigration powers to Scotland, the government needs to accept the court's ruling that their illegal migration policies are themselves illegal. It's time to establish instead safe and legal routes for people who are fleeing wars, famine and climate change. And at the very least, they need to pay attention to the amendments passed and about to be passed in the House of Lords. And she urgently needs to respond to the Council of Europe's Anti-Torture Committee, which has found incidents of inhumane and degrading treatment of asylum seekers at the Marston facility. But ultimately, Mr Speaker, the message from the court is clear. Enough with the language of stop the boats. It's time to stop the bill.
Well, I disagree, as you can imagine, with pretty much everything the honourable gentleman has just asserted there. But in particular, I want to make it clear that I have the utmost respect for the Court of Appeal. Senior judges considered this appeal in the right and proper manner. And whilst we maintain our respect for the judiciary, it is entirely legitimate for us to disagree with points that they have made and certain findings. And that's why we've made it clear we do disagree with some of the findings delivered today in the judgment, and that's why we're seeking permission to appeal against them. But, Mr Speaker, let's just be clear. The SNP are only interested in asylum seekers if they're housed elsewhere in the United Kingdom. Just last week, the SNP government and the Labour leader of Edinburgh Council conspired to oppose us using a vessel to accommodate asylum seekers in Leith. That same vessel in the same berth that had until recently housed Ukrainians. So, Mr Speaker, despite this having been value for money, despite being offered more cash to help, despite Edinburgh taking fewer than its fair share of asylum seekers, it is staggering to witness the stench of hypocrisy that hangs heavy over the SNP's fake humanitarianism.
Sir Edmund Lee.
Meanwhile, constituencies are overwhelmed, just as we are going to be with local services at RAF Scampton. So I'd like to know what alternative plan there is, by the way. But can the Home Secretary not realise that every year we produce a migration bill, every year we're tied up in knots by human rights lawyers, and what we've been suggesting for 2 years in the Common Sense Group is that the Refugee Convention is made for a different world, as well as the Human Rights Convention, and we simply have to have a derogation so that we can detain people and then deport them, and we'll never solve this problem otherwise.
Well, again, I put on record my thanks to my right honourable friend and his community for their support when it comes to RAF Scampton. I know that they have very serious concerns, and we are working intensively with him and the local authorities to enable the site to be rolled out and for the appropriate support to be put on for those who will be occupying that site. But when it comes to the legal framework, well, he makes a very powerful point. Last year, we saw the operation of the Strasbourg court operate in a way that was opaque, that was irregular, which was unfair, frankly, when it comes to the will of the British people. And that's why we've included measures in our legislation currently making its way through Parliament to avoid that scenario repeating itself.
Chiomora. Thank you, Madam Deputy Speaker. Having crashed the economy, impoverished so many of my constituents with the Tory mortgage premium, and utterly failed to deliver the economic prosperity that they need, the one policy that was supposed to distract from all this chaos is shown to be, as we have always said, it is shown to be unworkable as well as being immoral and eye-wateringly expensive. Why doesn't she just fix the asylum system instead of trying to outsource it?
Exactly.
Yeah.
Productivity is hard.
Well, I mean, it's pretty rich coming from the Honourable Lady to complain about our plans when her party has put forward a series of botched policies, flip-flops, U-turns and changes when it comes to the economy and energy prices, and moreover when it comes to stopping the boats and illegal migration. They have no plan. They do not speak for the British people, they speak for their vested interests, and they'd rather campaign to stop the deportation of foreign criminals and vote against every measure we have put forward to reform our asylum system than be on the side of the British people and stop the boats.
Françoise.
Deputy Speaker. We all know that the Home Secretary's instincts on this are right. However, the wider government promised to stop the boats, and we clearly haven't stopped them yet. So I fully support her decision to seek leave to appeal to the Supreme Court, as I think will most people in this country. But given legal procedural issues and judicial recesses, it could now take months for the case to reach the Supreme Court, let alone for a judgment to be handed down. In the meantime, the boats will keep coming, now probably all summer. So can I ask the Home Secretary two quick questions? One, with her extensive legal experience, is there anything that can practically be done to expedite the Supreme Court's decision in this case as soon as possible? And secondly, ultimately, wasn't my right honourable friend from Gainsborough right? The only way we will ultimately solve this problem is to achieve a derogation from the ECHR.
Just before the Home Secretary answers those two questions, I've been very lenient to the honourable gentleman, but this is not setting a precedent. Each member who asks a question gets one question. On this occasion, I will allow the Home Secretary to answer both of the questions, but I am not creating a precedent. One question, and we don't need an opening preamble either, just a question. Home Secretary.
Well, my right honourable friend speaks very powerfully. In terms of the timeline to which we are subject, the Court of Appeal has asked for submissions on permission to appeal by the 6th of July, and we will adhere to that timetable. I think you'd agree that that is quite a swift timetable. Thereafter, it is in the court's hands. And I am encouraged by paragraph 16 of the summary judgment, which does note the need for swiftness when considering this matter. But ultimately, the court sets the timetables, and we will follow any timeline they set.
Tim Farron.
Thank you, Madam Deputy Speaker. 160,000 asylum seekers languishing in this country awaiting a decision. Wouldn't the best deterrent be to actually be competent and process those 160,000 people, and then you return the ones who are not genuine refugees? Wouldn't not that send out a message? Isn't there a comparison between what has happened today and that 160,000 backlog? And they are both down to the incompetence of the Home Secretary, who seeks to distract us by playing games like this.
You should explain what
I don't think this is about playing games. This is about saving lives. This is about saving lives, and diminishing it in that form doesn't do justice to the complexity and the enormity of the challenge that we're all facing. we are making progress. As the Prime Minister set out a few weeks ago, we're making progress on the legacy backlog of the initial decisions, which has now fallen by 17,000 cases. And that's thanks to measures and interventions that we have introduced, like streamlining the process, increasing the number of caseworkers, and making decisions in a swifter fashion. And step by step, we will bear down on this backlog as we've promised to do so.
Philip Hollaback.
Thank you, Madam Deputy Speaker. My constituents in Kettering are completely fed up with Labour's opposition and delay to the illegal migration bill, and they're also completely fed up with the courts frustrating the Rwanda plan. Will the Home Secretary answer for my constituents this question? How on earth can Rwanda be deemed to be not a safe country when the UN Refugee Agency itself has its own asylum scheme, part funded by the European Union, to send asylum seekers to Rwanda?
Well, my honourable friend makes a very, very good point, and that's why I refer him in particular to the dissenting judgment of the Lord Chief Justice in the quite long judgment, but if he has the time, particularly paragraph 498, which sets out very similar points that he's just made now. And he finds that there are strong grounds to disagree with the other judges and find that there is no real risk of people who are being relocated to Rwanda being treated in an unsafe or unlawful way. And I take a lot of confidence from his dissenting judgment.
Olivia Blake.
Thank you, Madam Deputy Speaker, and I point members to my declaration of interest as I receive support on these issues from RAMP. I'm the co-chair of the APPG on migration. I would like to ask the Secretary of State if she would be willing to sit down with myself and some Afghan refugees who arrived here on small boats and explain what she meant in her statement by phony humanitarianism, a deeply offensive phrase. I hope you agree.
Hear, hear.
Well, I've met refugees, and I've met people who have come, fled persecution and sought humanitarian protection. And I'm very proud of what this country has offered and the tradition of the British people to extend the hand of friendship and the hand of compassion to those in need, with 500,000 people coming to our shores, fleeing persecution for humanitarian purposes. What I do object to is people fleeing a safe country like France, paying evil people smuggling gangs, risking their lives and the lives of others in the pursuit of an illegal trade. That is what we're trying to stop, and I wish you would get behind it.
Jane Stevenson.
Deputy Speaker, I thank the Home Secretary for her statement and for her assurance that she will appeal this as quickly as possible, because as my right honourable friend said, speed is of the essence now. My constituents want to see a fair and just asylum system, the boats stopped and the people smugglers put out of business once and for all. Does she share my despair that the only answers we hear from the benches opposite are, we won't have a queue when we just open the doors?
Yeah, that's right.
Well, again, she's absolutely right. The benches opposite would rather put all their efforts into campaigning to stop us deporting foreign criminals than support our legislation to stop the boats. They'd rather vote against all of our measures to improve our asylum system than stopping the boats. They are a joke. They are not on the side of the British people. They're on the wrong side of this argument again.
Jim Shannon.
Thank you, Madam Deputy Speaker.
That doesn't mean that we're at the end of the statement. It just means that in the circumstances I'm being kind to the honourable member for Strand. Jim Shannon.
Madam Deputy Speaker, I'm sure the Secretary of State was probably saying, great, it's all over. I jest, it's not fair to jest, it's a very, very serious matter. Whilst I agree with the Secretary of State that there must be an end to boatloads of young refugees circumnavigating the system in place, the court has determined that the risk of refoulement from Rwanda to other countries from Rwanda means that government's policy isn't legally able to be carried out. Will the Secretary of State outline how she believes the United Kingdom of Great Britain and Northern Ireland can stop the influx while fulfilling our human rights obligations, which is not just a legal matter,
but it's also a moral one. Thank you.
Well, he is right. This is not just a legal matter. It is a moral one, and it is of a political salience that I've not seen for a long time in our country. The vast majority of the British people want us to stop the boats. They want us to fix this problem, and that's why I'm encouraged with every step that we take on this journey. But the reality is that we believe in the lawfulness of our agreement with Rwanda, and as the court found, the conditions in which people will be accommodated in Rwanda per se are lawful, and they will be treated lawfully and humanely. It is about this issue about whether there's a risk of refoulement, that being them being relocated onto a third country which may not be safe. And that is the issue that where there is a point of dispute within the judgment. We are seeking permission to appeal. We believe in the lawfulness of this scheme, and we have confidence in delivering it as soon as possible.
A 33-year-old man seeking asylum and housed in a hotel in Skegness has very recently been charged with the rape of a stranger in a public park. The Home Secretary knows how outraged people in Skegness are. She knows from our conversations how outraged I am. Does she agree with me that any setback to the government's policy to stop the boats is something that will be greeted with horror by local people in Skegness? And does she agree with me that she should appeal this judgment as quickly as possible, but she should also pursue the illegal migration bill through Parliament as quickly as possible, and that anyone trying to stand in the way of that is fundamentally disagreeing with the rightly held, legitimate views of constituents such as mine?
Well, my honourable friend puts it very well, and from our discussions, I know how energetically he is advocating on behalf of his local community as they bear some of the burden relating to this national challenge. It is a fallacy, one that the opposite benches seem to indulge time and time again, that everyone coming on these boats are coming for humanitarian purposes, are fleeing some form of persecution. The reality is that a large proportion of them are coming for economic reasons. Many of them have chosen deliberately to leave a safe country like France, pay people smuggling gangs large amounts of money in the pursuit of a life in the United Kingdom, not as a refugee, not for humanitarian reasons. And it is that this poses public safety issues. It poses protection of our borders, is about national security. That is why it is imperative, it is essential that we do fix this problem and that we do stop the boats.
Karen Smith.
Thank you, Madam Deputy Speaker. We've learnt a few things today. We've learnt, firstly, that the Home Secretary respects the courts, which we should be grateful for. After 13 years, the government has got a rigged system. And thirdly, that we're going to continue to pour taxpayers' money into her failed system. Her bill in August will stop asylum decisions and mean people in detention will not be moved on even further. Given the number of people we've already got in hotels, how many more detention centres and hotels is she going to need, and at what cost?
Well, what we know is that 45,000 people arrived here illegally last year. It is costing the taxpayer £6 million a day in hotel accommodation, totalling £3 billion a year to service our asylum system. That is an unacceptable situation. We are proposing a plan through our illegal migration bill, which means that if you arrive here illegally, you'll be detained and thereafter swiftly removed. That, in combination with our world-leading partnership with Rwanda, will inject the deterrents necessary to stop the boats.
Danny Kruger.
Madam Deputy Speaker, unless you actually believe in open borders, you simply have to have a policy of detaining and removing illegal immigrants, either back to their own country or to a safe third country. There really isn't any other option. So the policy is the right one, and I'm glad that the court has concluded that the policy complies with the Geneva Convention and that Rwanda itself is a safe country. The problem, as the Home Secretary has been saying, is with Onward relocation. Previously, the government negotiated a deal with Jordan that enabled the return of Abu Qatada. Does the Home Secretary agree that in order to win our appeal, it might be necessary and helpful to get some sort of commitment from the Rwandan government that they will not be returning asylum seekers to places where they might be persecuted? Can she undertake to negotiate with the government, the Rwandans, to achieve that? And how quickly do you think we might get the planes to take off?
Well, we are in constant and ongoing discussion with our partners in Rwanda, and I'm very grateful for their statement today, which reiterates and reconfirms their commitment to our partnership and their determination to deliver it. They have a strong track record of supporting 100,000 migrants and refugees from their region. They work with the UNHCR. They are a safe country, as we maintain. But there is, we will always review our arrangements, and we'll always ensure that they are the best, in the best possible state that they can be.
Helen Hayes.
Thank you, Madam Deputy Speaker. One of my constituents has applied for his wife and daughter to come to the UK from Afghanistan, where their human rights as a woman and a girl are currently being denied by the Taliban on a daily basis. The Home Office refused their applications, but a court disagreed and ruled that they should be allowed to come. My constituent is distraught that the Home Secretary is choosing to appeal, seeking to stop this family from fleeing persecution and being reunited in the UK via a safe and legal route. Can I ask the Home Secretary why she thinks it is a justifiable use of taxpayers' money to keep challenging the decisions of our courts, as she has announced today in relation to the inhumane and failed Rwanda scheme, rather than taking responsibility for the failures on her watch? Yeah.
What is inhumane, I'm afraid to say, is the opposition party's stance on this subject. They maintain a principled objection, a ludicrous objection, frankly, to our measures, which will save lives, to our measures which are humanitarian at core, to our measures which will break the people smuggling gangs. The fact that they continue to oppose these humanitarian measures is beyond me, and frankly not in keeping with the tradition of the Labour Party.
Leonici.
Deputy Speaker, Home Secretary, I spoke with a constituent on Victoria Street, Grimsby, a few weeks ago, and he said to me that we will never send illegal migrants back to Rwanda because the left-wing establishment will never allow it to happen. Is he right?
The Prime Minister and I have made a promise to the British people to stop the boats. I believe that is what the British people want us to do, fervently and passionately. We are working day in, day out, flat out, to deliver the measures, to deliver our bill, to deliver the extra resources, to deliver our partnership with Rwanda. I believe we will deliver on that promise, and we will get there in the end.
Ruth Cadbury.
Thank you, Madam Deputy Speaker. The only policy idea that the government has is unravelling in front of our eyes. They've built an entire legislation around this idea that's just not working. They're also admitting that delays in processing asylum claims is part of their deterrent strategy. So what's her backup plan?
Well, I mean, I asked Victoria, what's her plan? Her plan is to throw a bit more money at the NCA. Her plan is to speed up the asylum system. And her plan is to add more safe and legal routes. Well, frankly, that's not a plan. And I really urge those on the Labour benches to take a long, hard look at what they're proposing, because they don't have a plan to stop the boats. What they're proposing is open borders and an uncontrolled migration. It is not a plan and is not what the British people want.
Aaron Bell.
Thank you, Madam Deputy Speaker. I believe this is fundamentally a question of democracy. The British people have repeatedly voted for control of immigration, and my constituents in Newcastle-under-Lyme expect us to stop the boats. And I'm actually grateful for a lot of the confirmation in the ruling today that the policy itself is legal. So will the Home Secretary do whatever is necessary, whether legally through appealing the ruling, whether through getting a memorandum of understanding with the Rwandans on the one point that the government lost on, or through legislation in this House to make sure we do deliver on that promise and stop the boats?
Well, my honourable friend speaks for the British people in his powerful question there. My answer is simple: yes.
Stella Creasy.
Thank you, Madam Deputy Speaker. Contrary to what the Home Secretary has just tried to tell the House, the vast majority of those in the boats are Iranian and Afghan.
just 1% are Albanians. And Iranians and Afghans have an asylum grant rate of 98% because, surprise, surprise, given what's happening in those countries, they are refugees fleeing persecution. So the only phony here is the Home Secretary's attempts to avoid responsibility for why she's spending so much taxpayers' money on a policy where she clearly, from the judgment, and yes, I have read it, didn't do her due diligence. Now, the Home Secretary will have had to put forward a budget. She says that this government is going to do whatever it takes to make this policy work. Are they going to spend whatever it takes? And will she be honest with the British public about how much money she has allocated to continuing on this folly and saving her blushes in the run-up to the general election that could go towards just processing cases and getting the backlog down?
Well, I'm not in the business of taking lectures from Labour on this issue. The reality is that last year there were 12,000 Albanians who came.
The Honourable Lady has asked her question. It's discourteous for her to sit there repeating it again when the Home Secretary's answering it. A bit of courtesy is necessary on all sides. Home Secretary.
Thank you, Madam Deputy Speaker. Last year, 30% of those arriving on the boats came from Albania, a safe country, a country where they are not feasibly fleeing persecution or torture. And so it is, again, a fallacy to suggest that everyone coming on the boats is somehow vulnerable or coming here for humanitarian reasons. The vast majority are young, healthy men. The vast majority are paying willingly for these journeys. They are procuring them from people smuggling gangs, criminal gangs, and they are coming here knowingly, willingly, breaking our laws to seek a better life. That is not what humanitarian protection is all about. That is not what refugee status is all about. That is why we need to stop the boats.
Dr. Kieran Mullen.
Deputy Speaker, I agree with the Lord Chief Justice, and despite what we've heard from the benches opposite, that's one of the three judges who thought we were right. These are really finely balanced issues. But of course, the court was preoccupied with the ability, not so much of the Rwandans to host asylum seekers, but to process their claims. We might find ourselves with other countries that will be willing to work with us, perhaps are also not as able to evidence their ability to process claims, as well as they can evidence that they can look after people. In that regard, can she update the House on plans to allow us to process claims ourselves whilst people are in a third country so that we can overcome some of these barriers?
Home Secretary.
Well, we have in recent months put in a huge amount of extra resource focused on the processing of asylum claims. We've increased the number of caseworkers, and we're on track to have over 2,000 caseworkers by September. We've we've improved and streamlined the process. We've simplified the guidance so that we can make decisions and process cases more quickly and more swiftly.
Christine Jardine.
Thank you very much, Madam Deputy Speaker. I actually agree with one thing that the Home Secretary has said today. This is hugely frustrating because the majority of people in this country do want to see an end to the vile, evil people smuggling which is costing lives in the Channel. But perhaps the time has come to accept that this immoral, unworkable, expensive scheme, which has now also been found to be illegal, is not the correct way to go about it. And perhaps the Home Secretary might consider those voices from all sides of the House which are saying add more safe legal routes, clamp down on the people smugglers, end the backlog and fix the system.
What's frankly immoral is the position that the Lib Dems have taken in this whole debate. By opposing our measures, by opposing our humanitarian plans to save lives and stop the people smuggling gangs, they have put themselves on the same side as the criminal people smuggling gangs, as open borders. That is what is not moral. That is not what will save lives, and that is what will not stop the boats.
Kerry McCarthy.
Thank you, Madam Deputy Speaker. Let's be clear, we all want to see an end to the small boats crossing, and it's wrong of the Home Secretary to try to mischaracterise the Labour position on that front. But the Rwanda policy, if you can call it a policy, was never going to make sufficient inroads into the numbers of people seeking asylum here to make any difference at all. As the Shadow Home Secretary said, it's political hyperbole, it was a total con. Can I ask the Home Secretary again, and can this time, because she not tried to make me answer the question, what is her plan if Rwanda isn't an opportunity for them to address the issue?
Well, it's not over yet. This is a Court of Appeal judgment. We've made it clear that we're seeking permission to appeal it, and we will await the outcome of the next level in the process and the next decision from the courts. So it is premature, frankly, to assume that this is the end of the policy. We maintain a high level of confidence in the lawfulness of the policy. We are committed to delivering it, and we're committed to working in partnership with Rwanda.
Ellie Reeves. Thank you, Madam Deputy Speaker. Today's judgment says that Rwanda's physical capacity for housing asylum seekers is limited to 100 people. That represents less than 0.5% of the people who crossed the Channel last year alone. Why on earth, then, has this government already given £140 million to Rwanda for what is clearly an unethical and unworkable scheme?
Well, both Rwanda and the United Kingdom have made it clear that the scheme is uncapped. And indeed, when I visited Rwanda a few months ago, I visited some of the new accommodation that is being constructed for the precise purposes of supporting people who will be relocated to Rwanda. So, with respect, I disagree with her, and there is potential in our agreement with Rwanda. We have confidence in its lawfulness, and we hope to deliver it as soon as possible.
Richard Ford.
Thank you, Madam Deputy Speaker. So the Court of Appeal has ruled that the government cannot send refugees to Rwanda. The scheme would cost taxpayers tens of thousands of extra pounds per refugee, yet the government still seems to want to spend extra millions to challenge the ruling in the Supreme Court. Has the government thought instead about simply paying for the Arsenal football team's Visit Rwanda sponsorship deal? Because it would cost less and it would achieve more than this gimmick of a scheme.
Well, what disappoints me is that the honourable gentleman is failing to grapple with the challenge and the costs that we are incurring right now, that being £6 million a day on hotel accommodation, £3 billion a year on our asylum system. That cannot go on. And that's why the Prime Minister and I have pledged to do whatever it takes to stop the boats, to bear down on our asylum backlog, and to deliver our legislation and our partnership with Rwanda.
Ruth Jones.
Thank you, Madam Deputy Speaker. Today's judgment is clear that Rwanda has repeatedly breached its Memorandum of Understanding with Israel. The Home Secretary is a lawyer, so why is she handing over hundreds of millions of pounds of taxpayers' money without doing the basic work to check that the arrangements are legally sound?
Well, this judgment and this dispute is about our partnership and our agreement with Rwanda, which was secured last year. And as the Lord Chief Justice found, that it is subject to robust monitoring, a committee that inspects its operation, and very strong and robust assurances from Rwanda on its delivery. Those give me confidence, and that's why I'm determined to roll it out as soon as possible.
And finally, Andrew Weston.
Thank you, Madam Deputy Speaker. A third question on the government spend on money here of the last four, because the judgment today stated that the Rwandan system for refugees is neither reliably fair or effective. Why then did ministers sign up to sending £140 million to Rwanda without checking this first?
Well, we've been upfront about the costs of our partnership with Rwanda, and that is a matter for public record. But what is absolutely clear, and I'm sorry that I have to repeat it again, John doesn't seem to be getting the point. We are spending £6 million a day on hotel accommodation and £3 billion a year on our asylum system. That cannot continue, and that's why we'll do whatever it takes to stop the boats.
Thank you. That concludes proceedings on the statement from the Home Secretary. I thank everybody for taking part. Point of order, Sir William Cash.
Very much indeed, Madam Deputy Speaker. I strongly support what the Home Secretary has been saying, but I am concerned that when the bill from the House of Lords returns, which will be quite soon, we hope, which is dealing with these matters, that in the ping-pong, we won't in any way be inhibited by the fact that there are judicial proceedings being dealt with at this point in time, because it's going to be really quite a very important debate, and we really need to be able to do it with as much latitude as possible. So I seek your guidance. Perhaps you could give some thought to that, if I may.
Duty does not apply when legislation.
I thank the honourable gentleman, right honourable gentleman, for his point of order, and it is a point of order. That's a good start. And well, points of order aren't usually points of order. And I can assure the right honourable gentleman that sub judice rules do not apply while legislation is being considered. While the actual process of legislating is underway, sub judice rules don't apply. So the honourable gentleman need not worry on that ground. Thank you.
I beg to move that the House be now.
The question is that this House do now adjourn. Mr. David Davis.
Thank you, Madam Deputy Speaker. On the 20th of January last year, I opened a backbench debate on the use of lawfare and slaps by those seeking to suppress public debate, bully people into submission, and conceal vital information that is in the public interest. Free speech matters. That's a truism of our age. But why does it matter? There are many reasons, but an important one is that free speech helps keep our society clean, free of corruption, of criminality, and the abuse of power. Now, typically such corruption is curbed when whistleblowers expose it, when journalists in a free press report it, and when politicians or judicial authorities act on it. So overmighty men and organisations who have acquired their power and money through corrupt means hate free speech and use their wealth to suppress it. To do that, they use slaps, strategic litigation against public participation. Slaps are a suite of litigious techniques used by corrupt plutocrats designed to intimidate, suppress and destroy those same whistleblowers, journalists and politicians who are trying to expose malpractice. They're designed to do this even when the plutocrat has no substantive case at all. They're designed to grind down decent, honest, public-spirited people and ruin them. Earlier this week in the House of Lords, the government introduced the first legislative changes to designed to tackle this issue of lawfare, this issue of slaps. In the intervening period, the problem has been exemplified by the actions of the businessman Mohammed Mercy. Now, I've already named this gentleman several times in this House in connection with our former colleague Charlotte Leslie, who had to face 2.5 years of fighting Mercy's spurious legal claims against her. That court case was concluded in Charlotte Leslie's favour a few weeks ago. The judge found that Mercy's case failed on the facts, but importantly he also added that several aspects of Mercy's conduct gave real cause for concern about the intent behind his legal case. Mercy delayed the start of defamation proceedings, took an exorbitant approach to litigation, and pursued an unnecessarily complex case. He also pursued a data protection claim and defamation claim in succession rather than properly in one action, thereby spinning out the case and maximising the stress and cost on Charlotte Leslie. This was clearly an attempt to bully, intimidate and financially ruin Miss Leslie in order to suppress the truth. They are the classic characteristics of a slap case, designed to destroy free speech, not to deliver justice. The judge also noted that Mercy offered to drop his claim against Charlotte Leslie if he got his way and was given the green light to launch a rival group to Miss Leslie's Conservative Middle East Council, a clear attempt to blackmail the Conservative Party via a sort of judicial hostage-taking. These are all standard slap tactics, and this is unsurprising given that Mr Mercy was represented by Carter Ruck, the go-to law firm for every bad actor seeking to undermine and misuse British justice. But Carter Ruck is not the only law firm willing to aid legal intimidation by dishonest and dishonourable means, if they pay the right price. These include CMS, Mishcon Rea, Skadden, Taylor Wessing, Shillings, and Harbottle and Lewis. Now, Charlotte Leslie isn't alone in facing lawfare at the hands of Mr. Mercy. He's also suing BBC Panorama and has threatened The Guardian, Chatham House, and Private Eye. He's also used legal threats to bully King's College London into withdrawing a report on tax avoidance, tax evasion, economic crime, and the way this has impacted our public space and politics. The report was written in 2021 by the Right Honourable Member for Barking, who is a visiting professor at King's College and a long-standing campaigner against international corruption. The report was published in May 2022, but due to Mercy's threats, it was removed a few weeks later. This report was in the public interest, highly relevant to our debates on the role and influence of Russian oligarchs and on the economic crime bill. But access to it by the public, and indeed by members, was prevented. So why did Mercy do this? Because he did not like what was being written about him. Because our laws allow those with deep pockets to bully people, suppress negative commentary in the media, and stop us holding their actions to public account. Because he's rich enough to do it. But what was it that Mr. Mercy wanted to conceal with his slaps? Well, in a word, the truth. A long history of involvement in corruption, in bribery, and in buying access to politicians. And Mercy is a wealthy businessman who made large sums of money in Russia, Uzbekistan, Kazakhstan, and Nepal, all countries where corruption is rife. In 2005, Mercy made $4 million arranging the acquisition of a Russian telecoms company on behalf of a company he knew was secretly owned by a powerful Putin ally, the then Russian telecoms minister Leonid Reyman. He made another $1.5 million buying and selling on a Russian telecoms venture Comet that was backed by a Russian general. In the UK, Mercy used his fortune to gain access to powerful people. He coined the term access capitalism, describing his own attempts to gain access to the royal household and government ministers with payments to Prince Charles's charities and the Conservative Party. He and his partner gave £750,000 to the Conservative Party, and he makes no bones about what he thought he was buying. When the Pandora Papers were leaked in 2021, they exposed some of the most egregious instances of corruption, economic crime, and money laundering, and Mercy was in the thick of it. Following the leak, a joint investigation by the BBC and The Guardian revealed that he profited from a corrupt deal involving the Swedish energy company Telia and a high-profile kleptocrat in Uzbekistan. Now, most of their investigation relied on court documents and a settlement reached between Telia, the company Telia, and the US Department of Justice following a 4-year investigation into Telia's activities. A leaked internal company report described the activities of a consultant called Mr. XY, who it transpires is Mohammed Mercy. It said some of the payments to Mercy, and I quote, may have been utilised to improperly acquire regulatory benefits and or secure the go-ahead of the transaction. Improperly acquire regulatory benefits. The report recommended that Telia sack him. And it's not surprising, given that Telia's former chief compliance officer said he had been, and I quote, involved in one of the biggest corruption scandals we have seen in Sweden, close quote. Mercy helped facilitate a $220 million purchase of shares from a shell company owned by the daughter of the Uzbek president at the time. This share purchase was, in fact, a concealed bribe. That was the clear view of the US Department of Justice. Mr. Mercy himself pocketed a $500,000 success fee following the deal. He claims he was employed by Telia at a rate of $10 million a year for his advanced skills and aptitude for negotiating. But despite these apparent skills, he claims not to have realised a financial arrangement he helped design facilitated a multi-million-dollar bribe. Now, either he knew it was a bribe, or he was extremely naive and therefore grossly overpaid. I know my view, but I'll leave the public to decide theirs. This is precisely why the Right Honourable Member for Barking wrote about Mr Omersi in her report last year. This story had already been reported in The Guardian and the BBC. This is the first paragraph he wanted removed from the Right Honourable Lady's paper, and I quote exactly. "The figures behind the Pandora leak are mind-boggling, and the documents contain many scandalous stories which really confirm how utterly unlawful the abuse of offshore has become. The papers bring to light how Conservative Party donor Mohamed Omersi allegedly used BVI-based companies to profit from apparently corrupt deals between a Swedish telecoms giant and a key power broker in the kleptocratic regime in Uzbekistan. They reveal the offshore structures deployed by Putin's inner circle of oligarchs and allies to buy million-dollar properties along the Monaco seafront. They demonstrate that money flows into onshore tax havens, such as US states like South Dakota, where there's around $360 billion hidden in secret trusts, including money that could have been derived from corrupt regimes or criminal activities." End of quote. And this is the second paragraph he wanted removed. Comments from Mohamed Omersi, a Kenyan-born telecoms millionaire, who, as previously discussed, was named in the Pandora Papers, seems to confirm that political donations can have a sinister purpose, after he described his frustrations at what he called access capitalism. Omersi previously admitted to buying access to Prince Charles, and he's also donated $750,000 to the Conservative Party since 2017. He claims to have paid $250,000 to become a member of the party's advisory board, which has regular meetings with Boris Johnson and leading cabinet members, and claims he was promised the chairmanship of a new body, the Conservative Friends of Middle East and North Africa, a promise that has yet to materialise. The role would have given him significant power and influence, as he would have acted as a link between governments in the region and British ministers. Omersi is now mired in an international corruption scandal. End of quote. The Right Honourable Member for Barking's report, entitled Losing Our Moral Compass, was about illicit finance and its corrosive impact. It summarised and analysed the features of many corruption cases in the public domain. It was a well-researched and argued paper designed to inform public debate, written to show how dirty money threatens the integrity of our economy and our political institutions. Ironically, what followed illustrates how right she was. Within days of the report being published, King's College and the Right Honourable Member for Barking received legal threats. Through his lawyers at Carter-Ruck, Omersi branded the report highly defamatory. He demanded an apology and that passages referred to him be either changed or entirely removed. Omersi bullied King's College into removing the paper. As notional defenders of academic freedom, they should have stood up to him, but they capitulated in the face of his threats. And his threat effectively silenced the Right Honourable Member for Barking and suppressed her vital work, exposing economic crime and dirty money. We know that Omersi is no stranger to using his financial might to get what he wants. He's previously paid to meet senior members of the royal family. But organisations like the Conservative Party and Buckingham Palace take serious reputational risks in associating with people like Omersi. Omersi's attempts to remove important information from public view are a textbook example of strategic litigation against public participation. They're clearly an exercise in lawfare. So here we have an individual with deep pockets who can use British lawyers and courts to suppress the publication of information which is clearly in the public interest. This is done in the knowledge that lengthy legal battles will likely bankrupt politicians, journalists, academic institutions, whistleblowers and others who are brave enough to tell the truth about public corruption. Omersi, like many oligarchs with huge wealth of doubtful origin, is in the business of silencing people. His actions are an example of how the rich and powerful can silence anyone who criticises them. The kleptocrats, oligarchs and bad actors do not care if that means stifling free speech, academic freedom and public debate. And now they're even prepared to try to silence elected members of Parliament and to block the publication of information that's plainly in the public interest. We find ourselves in a dangerous situation where the abuse of the legal system is now damaging the very core of our democracy. The cases faced by the Right Honourable Member for Barking and by Charlotte Leslie serve as a glaring example of this. It's to the disadvantage of the whole country when public interest investigation by Tom Burgess, HarperCollins, Catherine Belton, Elliot Higgins, Open Democracy, Oliver Buller and the Bureau of Investigative Journalism are shut down. Fortunately, the government responded very quickly to our debates on this issue last January of last. It almost immediately held a major consultation, which resulted in proposals for reform. And on Tuesday of this week, it introduced the first anti-SLAPP measures and economic crime bill, currently making its way through Parliament. The measures will empower the courts to strike out SLAPPs before trial. They'll also prevent courts from ordering defendants to pay claimants' costs in relation to a SLAPP claim, unless misconduct by the defendants justifies it. Once a claim is deemed to be a SLAPP, the burden will be on the claimant to prove that their claim is more likely than not to succeed. If not, the claim can be struck out. This is a welcome reversal of the burden of proof. Taken together, these measures are a great win for those looking to shine the spotlight on economic crime and speak truth to power. But we must go further, Madam Deputy Speaker. As things stand, the measures only apply to economic crimes. Approximately 70% of the crimes listed in April 2022 Foreign Policy Centre report were connected to financial crime and corruption. But SLAPPs have also been used to silence reporting on human rights abuses, on labour practices, on regulatory non-compliance, and an array of other abuses that don't relate to economic crime. To be truly effective, we must broaden anti-SLAPP provisions so they apply to all defamation lawsuits. Because ultimately, we want to ensure that people like Wagner's chief, Yevgeny Prigozhin, who's been in the news this week, people like him are not able to silence and intimidate journalists, as he did to a Bellingcat reporter earlier this year. So I welcome the commitment by Lord Bellamy on Tuesday. The government will complete the jigsaw as soon as suitable legislative vehicle appears. And this issue will not end with reforms to defamation law. Data protection law and subject access requests are becoming yet another weapon for bullying people into silence. And we also need proper regulation of private investigators, who in many instances have enabled SLAPPs through intrusive and often illegal surveillance or hacking. Justice Nicklin, in the Charlotte Leslie case, said the tactic Mercy's lawyers used against Charlotte Leslie, bringing separate claims in succession, can be a hallmark of abusive conduct. I think he was being delicate in referring to SLAPPs. We could improve the government's proposals by allowing the courts to make the law firms and solicitors involved in SLAPPs cases pay the costs to the public purse, taking the fight directly to those who enable SLAPP suits. The London lawyers I listed earlier, Carter Ruck and the rest, have designed a litany of tactics not to promote justice, but to suppress truth, not to protect reputations, but to silence legitimate criticism, not to ensure accountability, but to cover up corruption. That behaviour should not go unpunished. They should be made to meet the costs of wasting the court's time. Our legal system is a source of pride. Britain is home to some of the fairest and best courts in the world. We cannot allow individuals with deep pockets and questionable motives to exploit our justice system and destroy our reputation as a trusted jurisdiction. Expanding anti-SLAPP measures will put an end to this perversion of our legal system, which seeks to intimidate, threaten and suppress British journalists, academics, civil society and sitting members of Parliament. We made good progress, but if we fail to understand the magnitude of this issue and fully address this problem, then, as the Right Honourable Member for Barking rightly stated in their report, we are truly at risk of losing our moral compass.
Minister, Mr. Mike Freer.
Thank you, Madam Deputy Speaker. And first of all, may I thank